Welcome to the Law, Your Money and You. I'm Roberta Sapphire, an attorney in Sharon.
I'm Camille Barron, a financial organizer and healthcare advisor, also in Sharon, Massachusetts. And today we have someone here who is very, very versed on elder law and some of the issues that are pertinent to that. He's going to tell us a little bit more about that and answer some of our questions.
Which includes probate, estate planning, and a whole lot of things. This guy's been around for a while and really knows his stuff. Thank you for coming, Barry Crimmins.
Thank
from
you very
Stoughton,
much.
Massachusetts, also New England. Welcome.
Right, thank you. Thank
We
you for
always
having
say-
me.
to tell us a little bit about yourself.
Sure. So I've been a resident in the neighboring town of Stoughton all my life. I won't tell you how many years that is, but I've lived in Stoughton all my life, and I've been practicing law now for over 30 years. I have an office in Stoughton as well as offices down the Cape. So I travel back and forth between, really we go anywhere from Boston down to the Cape. A lot of what we do involves clients that can't always get to our office. So the nature of elder law often finds us having to go to clients' homes. Sometimes we're going to a nursing home and sometimes to a hospital. So we have to travel in order to do what we do, but it's part of one of the reasons I like it, because it gets me out of the office and I'm not just stuck behind a desk all day long.
Great. Now, can you tell us the difference between elder law and estate law?
Okay,
Good
sure.
question.
So elder law is what I like to refer to as a type or a subset of estate planning that is geared towards the issues that tend to be somewhat more unique for older clients, older folks. Estate planning, even that term sometimes is misunderstood because, as you said, Camille, as either a financial planner, you're often advising your clients in where to invest their money, depending on their objectives, their risk tolerance, and the like. As an estate planner, as opposed to a financial planner, we're less involved with where the clients are going to be investing that money. More so, we're involved with help protecting those assets as much as possible, and we can talk about that, I'm sure, but also making sure that those assets are going to pass to the intended beneficiaries when the client passes, and also making sure that there are documents in place in the event of an incapacity. So with elder law, we tend to focus on a lot of the same issues we do with estate planning for younger clients, but it's geared towards the issues that tend to be more unique for elders. And what are some of those issues? The one that I just alluded to a moment ago, incapacity, whether that's due to Alzheimer's or some other form of dementia, or something of that nature. And also one of the big issues in the elder law area is Medicaid or mass health planning. So a lot of clients are concerned about what happens if they have to go into a nursing home, either they or if they're married, a spouse, and what can they do to protect their assets, and especially what can they do to protect their home. Those are some of the bigger concerns that we hear from our clients all the time.
Sure. And what are some of the documents, some of the things that you put together for people who are in that capacity?
Yeah, no, that's a very good question. So typically in an estate plan, we're looking at some documents that I think a lot of your viewers would be accustomed to. Traditionally, we're looking at wills. We're looking at trusts, and it could be different types of trusts depending on the particular situation. We're looking at, again, documents to address issues of incapacity, and those typically involve powers of attorney, healthcare proxies, and HIPAA authorizations. And then the final couple of documents that typically go along with a traditional estate plan would be a living will. It could also be a declaration of homestead if somebody owns a home. It's a very important document to help protect their home. And then for younger clients, there's a document referred to as an emergency guardianship proxy in case something happens while they're away and something needs to be done with their minor children on a short-term basis before a guardian could be put into place. When we're dealing with our older clients, more in the realm of what we typically refer to as elder law, we may have those very same documents, but probably the biggest difference is in the area of trust. Because if we're creating a trust for somebody who is concerned about so-called long-term care planning or what happens if they go into a nursing home, that trust has to have certain characteristics to it in order to make it what we refer to as a Medicaid qualifying trust. So unfortunately, often what we run across is a lot of clients have created trusts in the past, and often they may have transferred their home into that trust. And that may be perfectly fine if the sole purpose of that trust was probate avoidance, avoiding their estate having to go through probate at the time of their death. But that same trust that would work for that limited purpose is not going to work if that client needs to go into a nursing home and needs to get onto Mass Health in order to pay for that nursing home care.
So question.
Sure.
I mean, there's different entities. You know, you've got corporations, LLCs, and trusts. Now, these kind of trusts, I've had people say to me, well, do I have to file a tax return on this trust if I put my house in a trust? Do we
So, like most answers to questions in our field, as you know, Roberta, the answer often is it all depends. However, in most cases, these trusts are not a separate taxable entity. They are what is referred to as a grantor type trust, and as such, the income and expenses of the trust pass through to the beneficiaries.
Would you call that a nominee trust too?
Well, a nominee trust can be a grantor type trust. Typically, a nominee trust is one of those trusts that I alluded to when I said people who have put their homes into a trust. And it's really more akin to a principal agency relationship, because with a nominee trust, the trustee really doesn't have any independent authority. The trustee really acts solely at the direction of the beneficiaries. So once again, that type of a trust is fine for probate avoidance purposes, but it's not going to work for purposes of qualifying that person if they need to go into a nursing home and need to get onto Medicaid or Mass Health.
Okay, one more question.
Abs-
You're good, I can't trap you. One more question. Here's one where they go, well, what if I, like an older person, what if they give themselves a life estate?
Right,
And
right.
then when they pass on, they either want to give the other spouse a life estate or they want it to go directly to the kids where they fight over it.
Sure, sure. So with a life estate deed, which, as you know, is a form of deed whereby somebody conveys the future interest in their property, often to their children, and they retain the present interest in the property. Oftentimes that's done, amongst other reasons, it's done for probate avoidance purposes. Once again, that's often a consideration for many things that our clients are looking to do in this area, because since there are what would amount to beneficiaries with the life estate deed, or remaindermen as they're typically referred to, that property is going to pass to those remaindermen at the death of the life holder without the need of having to go through probate. The downside that I see and a lot of clients have a concern with is less so what happens at the time of death, because the property will pass to the remainderment, but rather what happens if during their lifetime they decide they want to sell that property.
Or they go a little off.
Well, right. And so now they can do so. They can sell the property, assuming they're competent to do so. They can sell the property, but now instead of just them signing the deed themselves, they also need to have those remaindermen sign the deed as well. And we have run into cases in the past where a remainderman has refused to sign a deed. And so it can thwart the intent of the individual if the person or persons who they have named as the remainderman won't go along with the sale.
What happens if the person is, Alzheimer's, and meanwhile they still have a life estate?
Right. So that's one of the reasons why I really think that you could say all the documents are important, and they certainly are. Those documents that I mentioned that make up a traditional estate plan, but the incapacity documents are often overlooked because they're not documents that a lot of times our clients are accustomed to or have grown up thinking about or talking about. Most of us have a notion of what a will is and what it's designed to do. Some also have an idea about a trust and what that is designed to do. But many times people aren't as familiar with powers of attorney and healthcare proxies. And we emphasize to our clients that those documents are critically important because without them, if a client doesn't have those documents in place, and then as you mentioned, an issue of any form of incapacity arises, Alzheimer's, etc., then the only alternative if those documents are not in place is somebody's going to have to file a petition with the probate court to get appointed as either the guardian or the conservator of that individual. And so that, once again, is a public process involving the probate court, involving notice in the newspaper so folks know about it. And it can take time, and since it takes time, it can also cost money.
Yeah. Well, Camille does a lot of patient advocacy and talking with people about where they should have this or that. Do you ever have issues like that with the incapacity? Or
Well, yes.
like that?
So we kind of have estate planning attorneys that we sort of partner with.
This guy's great.
Yes, so we'll have
Really,
one more.
really excellent.
And
Yeah.
so that really doesn't fall into our hands all that much. But it is definitely an issue, and when the time comes that happens, then we have to refer them and get somebody else involved.
Right. We work closely with financial planners and other financial service advisors because typically our clients, again, they're coming to us looking for guidance with estate planning. Sometimes they've already been to a financial planner, sometimes they haven't. I had a client in yesterday that asked us for a referral to a financial planner because she recently lost her husband. She doesn't have a financial planner. So we work, as Camille mentioned, very closely with financial planners, with CPAs, with other financial services professionals. It's sort of a collaborative effort on everyone's part for the best interest of the
Well,
client.
she's a medical planner too.
Well, the company is, but I'm not personally.
Oh.
The company does both patient advocacy,
Yeah, well, she
health,
looks out
healthcare
she looks out
issues.
for everything.
My specialty, of course, is the insurance.
Yeah, oh yeah.
But we do have
yes.
people, as I mentioned to you before, Barry, that we certainly have people on Medicare because that's one of our specialties,
Right.
retiree health insurance.
Right, exactly.
And also, in some cases, somebody might be on Medicaid,
Right.
also known as Mass Health in this state,
Right.
but Medicaid in others.
Right.
So I know that you have talked about issues. You talked about some of the rules, and in fact, most recently, I'm looking at the September newsletter.
His newsletter's fantastic.
It is great,
Yeah.
and you talk about a new
Okay.
rule that may make it harder for Medicare beneficiaries to receive home care.
Right.
Tell us about that.
So one of the things that's happening, and it might be worth mentioning the difference quickly between Medicare and Medicaid, because I do find oftentimes clients are confused, and you also touch on the fact even Medicaid in Massachusetts is referred to as Mass Health, so even that
I didn't even
lends,
know that.
I think, to some of the confusion.
And I
So
should know.
we sort of have these three terms, two of which mean the same thing, but one of which is very different from the other two. It's like the old highlights book in the dentist's office. Which one of these things is not like the other? And so Medicare, unlike Medicaid is generally what we're dealing with clients who need to go into the nursing home. That's long-term care. That's residential care. They're moving into the nursing home and generally not expected to return home. So that's where Medicaid, or again, Massachusetts, it's referred to as Mass Health. They mean the same. Medicare, on the other hand, as you know, is short-term hospitalization. So that's when somebody goes into a hospital after an incident. They may have to go into a rehab facility for a short period of time, but they're expected to return home. And so Medicare is what sometimes is referred to as hospitalization insurance. So it's to cover the patient while they're in the hospital, but that patient is fully expected, at least is expected to return home. It's not necessarily a situation, although they often turn into situations where that person goes from a short-term stay at a hospital or a rehab facility, and all of a sudden that turns into a long-term stay at a nursing home because they're just not able to return home and live independently at home. But for many of the patients who are on Medicare, go into a hospital, get the treatment that they need, they are then able to fully return home and live their normal life at home. And I often also say that I've never had a client say to me that they want to go into a nursing home. To the contrary, most, if not all, will always say that they want to stay in their home as long as possible. But of course, it's not always possible for them to stay home, and sometimes situations arise where they do need to go into a long-term care facility. But Camille, back to your question. So, this area, there are so many regulations, and the regulations are constantly changing. And this is just one of those other areas where this deals primarily with the ability for patients to get in-home services and some of the things that might happen down the road that could affect their ability to do so. My wife is, if I can give her a plug, she's a visiting nurse for the Stoughton Visiting Nurses Association. So she deals with this issue all the time on a day in and day in basis. But this is an area, because of folks that want to stay home but need services in the home. We're fortunate that we do have agencies, whether they are visiting nurses associations, whether they're home health aides, any number of other services that folks can provide or receive in the home, many of which can either be covered by either Medicare or Medicaid, depending on the particular situation.
So was there some rule that changed for 2020?
Well, it hasn't. I was going to say it is expected to go into effect in 2020. I've seen so many different papers and articles about this with differing opinions as to what may happen or may not happen. I'd probably be remiss if I were to say exactly what is expected to happen now, because it always seems to go the other way. Or the regulations, the implementation of the regulations get delayed or never get implemented at all. I guess the operative word is to stay tuned, and we'll see what happens down the road. I'll be happy to come back on on the show in 2020.
That would be wonderful.
And I can update you and your viewers on what's happened with those regulations to try to really do justice to this topic. And there's so many topics within this field in a half-hour time frame is very difficult.
And there's that little, that slippery slope between being admitted to the hospital as an inpatient or being in the hospital for observation. We've talked about this before. So if you're in for observation,
they charge differently.
They charge differently, and you are not going to be covered if you go to a rehab facility.
So before you
You
go
have to
in,
be
you've got to
admitted-
call
you-
Camille.
Absolutely.
Or you.
Absolutely.
You have to be in a hospital as an admitted patient for 3 nights or more in order to be covered.
And I think one of the problems in that area, I think most of us just think that if we're in the hospital, if we're staying there, we have been admitted. And as you just mentioned, that's not always the case.
Well, they say you've got to be in the hospital before you go to the
to the rehab facility. Correct.
But you're saying you have to be there at least 3 days.
As an admitted patient.
Oh, as an admitted.
As opposed to being
Sometimes they
under
keep you just for
observation.
observation.
Right.
Yeah, and if it's under observation, I think there's different codes. I know my sister-in-law got hit with this. They said, look at the difference, in the price.
Right, right,
Yeah.
right.
Fascinating.
And the whole medical aspect, I mean, we tend to focus, excuse me, we tend to focus on the financial aspect of Medicaid or Mass Health and the financial qualifications or eligibility criteria. Well, of course, there's also a medical eligibility criteria. You have to be medically eligible in order to receive Mass Health as well. You can't just say, well, my income and assets are such that I want to go into the nursing home. There also has to be a medical reason for that, supported by your doctor in the hospital.
Yeah, so you mentioned earlier that there's a difference between having a trust that's designed to protect, to avoid going to probate,
Right.
but that may not be adequate for trying to protect your assets. Can you explain that?
Sure, sure. So again, there are many different trusts that are used for many different purposes. Sometimes trusts are referred to as being either revocable or irrevocable. Sometimes they're referred to as, you hear the expression, a living trust versus a testamentary trust. So there's different types of trusts for different purposes. Basically, in order for a trust to be what we refer to as a Medicaid qualifying trust. And by that, what I mean is when Medicaid reviews that trust to determine if the assets that are in that trust are going to be countable for purposes of determining an applicant's eligibility, they look at a couple of things. And generally speaking, what they're looking at is the ability of the applicant to control those assets. And because the emphasis is on control, regardless of what the specific language says, those trusts, in order to be Medicaid qualifying trusts, have to generally fit into a couple of different criteria. Number one, they do have to be irrevocable. If you can revoke the trust and get the asset back, then Medicaid is going to count those assets. It also has to be what we call income-only trust, such that the assets that are transferred into the trust, you cannot get the assets back. You can receive the income that's generated by those assets. So for instance, we typically talk about transferring the home into the trust, but many times we're also looking at transferring liquid assets, bank accounts, and other cash type of assets that generate interest income. So any of those investment accounts that may get transferred into the trust, the client, the Medicaid applicant, can receive that income, but they cannot take the principal back, okay? The third thing that we look at, and although it's not a specific requirement, is we tend not to have the client serve as the trustee of their own trust. We want the client to name some third person to serve in that capacity. It can be an adult child, but it doesn't have to be. It can be some other adult that they trust, but it should not be the client themselves serving as trustee, for the simple reason that, once again, because Mass Health is concerned with control, if the applicant is the trustee, invariably there's going to be some provision in that trust that Mass Health could interpret to mean that the trustee has the ability to either amend or revoke that trust and therefore get the assets back, and therefore we're going to count those assets. Keep in mind, a Medicaid applicant can only have $2,000 in so-called countable assets in their name, plus their primary residence, but only $2,000 in other so-called countable assets. So if assets were transferred into a trust, and those assets are deemed to be countable by Medicaid, then chances are that's going to bump the person up over the $2,000 amount.
And of course, the 5-year look-back period has to happen from the time
Still
that you
5 years.
execute that
It'll
trust.
probably be more.
You just have to hope that if you get to the point where you have to apply for Medicaid, it's after 5 years.
Exactly.
But the thing about the 5 years, I know because we experienced it ourselves, we refinanced our home. And no bank will give a mortgage to a trust.
Right.
So after we had met that 5-year period, well beyond it, we had to take our home out of that trust
Right.
to get the financing, to refinance, and then we had to put it back in.
Yeah.
So the clock starts
That's
ticking
right.
again for another
Right.
5
I
years.
wonder if this is we're in, you've got to be kidding, but I'm wondering if where it was your home, that they could have just homesteaded it, would that have been
Well,
counted
that
as
wouldn't
part
have
of?
addressed the issue that Camille is
Oh, the
raising.
5-year
The
rule?
homestead, again, is going to
Oh, that's
protect against creditor
Oh, yeah,
claims, but for refinancing or purchase of a property, banks are just funny that
They
way.
could though, Tim,
Yeah,
they could take a mortgage on it.
yeah, they could.
They could
They
have
get
taken
very
the mortgage
skittish
on it.
about trust. They don't like them. They tend not to necessarily understand them too well. With all my apologies to all your banker viewers out there, but it often results in just the situation that you described, Camille, where the client is transferring the property out. The other thing we often see, and we're dealing with a case right now where a client had property in a trust, and then obviously it came time to apply for Medicaid, and because of not reaching the 5-year look-back period, they then had to transfer the property back in order to become eligible for Medicaid. The problem that creates is that home, if it's just in the name of the Mass Health recipient, and then that Mass Health recipient dies with that home in his or her name alone, because it's a probate asset, it's subject to the Mass Health lien that arises upon the death of the individual. I'm sure we don't have enough time to get into that whole area now. But
that's a good. You've got
If
to
there's
be
a spouse
kidding.
still living at the home, it's still protected, but then when the spouse decides to
You've
sell
gotta
it,
be kidding.
then does the lien take effect?
Yeah.
well, no. Well, once again, it all depends, right? That's our operative
you've
word,
got to be kidding.
the word for today. It does illustrate, and maybe
Can't
the takeaway from all of this
Oh,
is
okay, thank you.
it's an area that, as I mentioned
Someone
before, with
agreeing
so
with you.
many regulations, and there are the rules, the exception to the rules, and the exception to the exception. And you'll see it on my business card. I'm a member of the National Academy of Elder Law Attorneys, so we're a specialized bar association that is made up of attorneys who deal in elder law, and it's not an area that you can dabble in. Sometimes you have attorneys
have
say,
to
well,
know
I
what
do
you're
a little
doing.
of this or a little of that. You really can't do that in this area.
You have to
It
keep up
really
with it
requires a
constant.
degree of specialization.
Yeah. Well, we're ending. You've got to
Wow.
be kidding. I'm gonna. You're really wonderful.
Oh,
You're really
thank you.
wonderful.
Thank you very
we
much.
appreciate
I think
you
you'll have
here.
to come back, though.
Yeah.
But so I want to end the show with a funny joke somebody told me. In fact, they're from Stoughton.
Go
Oh,
ahead. Go for it.
are there funny
Why-
people in Stoughton?
Yeah. Why did the watermelons get married in a church?
Why?
Because they can't elope.
I like that.
That's a
I
good
like
one,
that.
yeah.
That sounds like a joke, Roberta, that my father would have told. He was fond of saying, if it weren't for Venetian blinds, it would be curtains for us all. That's going to be my
I gotta
joke.
I gotta tell it
All right.
to this other guy. That's funny.
All right.
No, you're really wonderful. That's a wrap, and you've got to be kidding. God, I think you covered a lot, but there's always changes, always new. You didn't even hit on probate.
Right, there's so much in this area. We can do a 3-part series, maybe.
Okay,
Yeah.
we will,
Yeah,
yes.
yeah.
Yeah, I think that
Also,
sounds
what's
good.
interesting is they don't call them nursing homes anymore. What do they call them? Memory care centers.
Oh, yeah.
If it's for
bunch of
Alzheimer's.
baloney.
Yeah,
Yes.
right.
Yeah.
So, this has been wonderful. and
Yes,
I knew that it would
wonderful.
just,
Thank
it
you.
would just fly by.
Yeah,
and
it sure did.
Usually we end up not covering
Oh, it says
the
Reba.
things that we didn't cover that are
Right.
probably more than the things that we did.
Yeah,
That's just the way it
yeah.
goes.
Yeah, I
I
want to
think
know
so.
what's going down the Cape.
Yeah,
that you're
yeah,
down there so
yeah,
much.
no,
Yeah.
absolutely.
Nice color.
Yeah, well, thank you.
So thank you so much, Barry.
Well,
Yes,
thank you.
thank
Thank
you.
you for
Privilege
having
to have
me.
you on the show.
No,
We
it
would
was-
love to have you come
Yeah,
back.
absolutely. It
Yes.
was my
And
pleasure.
To our viewers, we want to thank you for watching. If you have any questions about this topic, please let us know, and we'll be sure to forward them on to Barry. And let's hear from you if you have any other ideas for topics or any other questions, because remember, this is your show, The Law, Your Money,
And
and
you.
you.